Okay, everybody, it's top of the hour. To respect everybody's time, I see a bunch of people jumping in, and we're going to get going here. Really want to thank everybody for being here. We know everyone's busy. It's going to be great. A lot of really good takeaway information. For those of you who don't know us, we are Barth Calderon LLP. We are headquartered here in Orange County, California, near Disneyland. I think this office up here overlooks Disneyland. You can see the Matterhorn. And we have been around for 33 plus years. We have about 12,000 clients across the country. We are an asset protection, estate planning, business planning firm, probate, and trust, which is the focus of our talk here today. And Phil is one of our top attorneys in high demand for these talks across the country. We do a lot of these. And our goal at the firm is always to give away good information that can help you, that is actionable in some way. And so we do a ton of these. I encourage you to stay connected with us. And I want to mention a few other issues here too, is that I put up in the chat there a link, and we always get questions, and we're going to make this interactive. We for sure want your questions along the way. Don't hesitate to put those in the Q&A would be great versus chat, because chat gets a little confusing, but put it in Q&A so we can address them and stay organized there. But that link I put in there is for you to get one-on-one with Phil. After this, if you have some personal questions about your own planning, that is 100% complimentary. Leave your checkbook at home. It's a chance for you to get acquainted with Phil, him to hear what you have, what's going on with you, and get some direction right there in that call, and have us help you as needed from there. So just click on that link. You can fill out that form. And Phil, welcome.
Thank you. Thanks for having me this morning.
Yeah, and if you hear some crying in the background, Phil just had a new baby, so forgive him. All right. Phil, what is that? Is it number 4?
Or it's me crying from no sleep.
You crying? Yeah, you have 4, right? 4?
I have 3.
Oh, 3. That's right.
Yeah.
I got 4, so Phil and I compete on the kids.
Yeah.
All right. I'm going to share my screen. I have a very simple slide deck here that we're going to follow along, just so you can see where we are, and it keeps me organized. So let me do that. And then we're going to jump right into it. And please ask away. Ask your questions. We love questions, and we will stop, answer them, and also have time at the end for Q&A. Okay, so this is an easy one here. I want to get into this. A lot of misconceptions, Phil, about what probate actually is. So can you get in? Let's dive into this. What is probate?
Yeah, so probate is the court supervised process of distributing somebody's assets that didn't have the proper planning. It can take a long time, depending on the state that you're in. The timelines vary. I can tell you we do most of our probates in California. Those probates prior to COVID used to be 6 months to a year. Ever since COVID, they have been anywhere from 1 year to 2 years they take. It can take 3 to 4 months sometimes just to get appointed. And what that means is that if you have like a house that needs a mortgage payment and you need to work with the lender because there's not enough money in the estate to pay it, that it could go into foreclosure before you ever have the authority to do anything about it. If there's a business, and this is the worst one, if there's a business, that business may have nobody to run the business for 3 to 4 months. Nobody can sign on the dotted line. Nobody can access the bank accounts. Nobody can, deal with vendors until that happens. And so it can take quite a long time and be very difficult.
Yeah, and we're going to get to the business and property section here in a bit. The cost, are there fixed costs with probate? Like what are the costs?
Yeah, so the states have their own cost regiment for probates. And basically it says in the statute, if the estate is worth X amount, then the probate attorney, as well as the personal representative of the estate, gets paid this much money. And that can be quite a lot. It's very rare that we get one that's less than $10,000. The majority of them are in the $20,000 to $50,000 cost, and that's for the attorney and for the executor. So you're talking double that amount. But you get some that are well over $100,000 cost. You really don't want to have to deal with that.
Okay.
Much
And Phil,
much cheaper to
somebody,
spend a couple thousand on a trust.
oh, yeah, yeah. And somebody just said they're getting feedback on the audio. So just I don't know what that is. We were on Zooms earlier, but um, so if anybody else has that problem, let us know. Okay, so you got the cost. What about the public exposure?
Um, the somebody it looks like Rick said something and then Stewart as well. Okay, so public exposure. So one of the benefits of doing an estate plan is that all your information is kept private. It stays out of the court. None of your beneficiary, none of your asset information gets filed with any government agency, any bank, anything like that. However, when you're in a probate, it's all public record. Everything that happens in the court system is public record. You could go down to your local courthouse and see what anybody had when they died, who their beneficiaries are. You see this with a lot of celebrities. James Gandolfini. Who was the most recent one? There was another one that was a big profile one. Do you remember who it was, Paul?
I don't, not off the top of my head, no.
Yeah. So if you ever want to know what any celebrities have when they didn't do the proper planning, you can go to your local courthouse and find out.
Yeah, yeah. Okay, awesome. Let's move along here. This is a big one. Common trust administration mistakes. Let's dig into this a bit, and if you could handle, some of these here, Phil.
Absolutely. So for those of you that don't know, trust administration is the process of distributing the assets after somebody dies when they do have the proper planning in place. And that proper planning usually involves at least one trust. You want to do the administration as quick as possible, but you need to wait at least at least one until you have death certificates, and two until the family has been taken care of and the funeral's done and things like that. It's not something that has to start right away, but there are a lot of deadlines. You have certain amounts of time to file things with the IRS, the franchise tax boards of each state, um, potentially with the beneficiaries. There's a lot of different deadlines that need to be met. And so you don't want to wait too long. If you do, you could end up with penalties and adverse consequences and really lose part of the estate. Uh,
Okay. All right. What about fiduciary duty?
yeah, so fiduciary. So the person that's in charge of the trust, they are called the trustee. The trustee is what's called a fiduciary in legal terms. And a fiduciary means somebody that has the responsibility of acting on behalf of somebody else. And when you are a fiduciary, there's a whole bunch of rules that each state sets up that fiduciary has to follow. Things like not using the money for your own benefit, acting in the best interest of the beneficiaries, not wasting the money, not mismanaging the money, things along those lines. And so it's a really big responsibility to have. And if you don't follow those rules, you could be one sued civilly and even potentially criminally charged for not doing your duty. Um,
Okay.
so it's really important that you understand what your fiduciary duties are and you have somebody to guide you if you don't know what they are.
No, very good. And Phil, do you have I guess a few other people are getting feedback. Is it your microphone? Are you doing something different there? Are you fine?
Now, is
Okay.
anybody other than Rick getting feedback? I see it's Rick. Do you see anybody else?
One other person said, but we'll continue because a few others
Let
said
me
no
try. Let me
feedback.
try turning down my volume.
Maybe the volume down. Yeah.
Is that any better?
Yeah, I can hear you fine. I don't know what I'm saying, but all right, we'll keep
Okay,
blazing
perfect.
along.
Rich said he's good now.
Okay. Oh, okay, good. All right. Elizabeth has a question. I'm going to allow Elizabeth. You want to ask your question? Elizabeth, you want to go? I allowed you to talk if you want to ask. You got to unmute yourself. You there? No. Okay. We'll see if there's a question that comes in. Um, okay. So this is failing to communicate with beneficiaries. Well, this gets into family breakups too, but what you're going to get to. But failing to communicate with beneficiaries, what is the best practice there, Phil? What do you see and what's been your experience?
Yeah, that ties in with the last bullet point. That's one of your fiduciary duties is you have to communicate with them. There are certain situations where you are required to give them notice for things. There are other situations where you're not required, but it may be in your best interest to do it, just to make sure that there's no opportunity for the beneficiaries to go back and challenge what you've done later. So it's usually good practice to communicate always, but sometimes you may not want to.
Why? Why wouldn't you want to?
I guess in the situation where you have a lot of beneficiaries that aren't getting along, we see it mostly with whether or not to sell an asset, like say parents' home. Parents die, all the siblings are beneficiaries, and some of the siblings want to keep the home because it has sentimental value. Other siblings just want the money and want to get out, and so maybe the best route is to sell the home, and it's not going to make all the beneficiaries happy. And so you don't have to communicate, hey, we got a $1 million offer on the house to every beneficiary or every offer that you get. And maybe wait to see how it plays out. And if it looks like there's a sale going through, then you may want to communicate with the beneficiaries, but you don't have to communicate every little step of that process.
All right, we'll get a couple questions on this. Who guides the fiduciary in their duties, if someone's asking?
Yeah, good question. So, you're always welcome to go through it on your own, but if it's not something that you know how to do, then you need to hire an attorney. Our firm does trust administration. We have, I think, 6 of our 17 attorneys do the trust admin, and we'd be happy to help you out with that.
Okay. And someone, Michael's asking, where can you get your fiduciary duties as the trustee? I mean, I guess where can you get an idea of what you're supposed to be doing?
Yeah, so that comes out of the California law. So you can look at the California Probate Code, Business and Professions Code, and there's different provisions in there. It's not just one place, unfortunately. It's in a bunch of different sections, and that outlines what the duties of a fiduciary are.
Every state has that?
Every state has that, correct? Yeah, sorry.
Oh, no. Okay. And then if obviously they can get it from a firm like us, an attorney like you're going to know exactly what the duties are when you're talking to somebody.
Absolutely. And I wanted to clarify. I'm going to keep talking about California because we're based in California, but we do help clients nationwide, and we are familiar with almost every state's laws. And for the ones that we don't have, we either have resources in that state or we can do the research and figure it out. So we can help anybody in any state.
Okay. All right. If there's a trust, this is another question, but the trust attorney was never guiding us in the duties, who is liable?
That's a tough one. So there's a lot of attorneys that set up trusts. Let me back up. There's a lot of people that set up trusts that are not even attorneys. You have document prep places, you've got LegalZoom, you've got We the People, I think, does it. There's a couple other places, and you're not going to get any guidance from them. There's no requirement that somebody sets up a trust, guide you in how to administer the trust. If it's not an attorney, they're definitely not going to know how to. And a lot of estate planning attorneys that set up trusts don't know how to, which to me is scary. Why would you go to somebody to set up a trust that has no idea how the back end of that trust is going to work when somebody dies? So you really want to find an attorney to set up the trust initially that knows how it's going to play out in the end.
Yep. Yep. And I've got to say that we get about, I don't know, maybe 5 to 6 calls a week. My team takes them from trust administration, and the whole after death stuff has gone like crazy. It's falling apart. It's trust litigation, which, you just want to avoid it getting to that part. We have another attorney that's doing trust litigation, and that's heinous. And so that's why if you follow this, you just want to do everything possible to get it where it gets to that point. Um, Philip Howell is asking, can you please let me know if you're available to chat? Yeah, so Philip, we do have a link. I'll put it back in the chat. There's a link in there. It's a tiny URL. So I shortened it to get one-on-one with Phil, no cost. So look at that. I'll put it up there again shortly when Phil starts talking here. But you absolutely can get one-on-one with Phil. Distributing assets too early, Phil. What is that about?
Yeah, so you want to be careful. I know when somebody dies, and you've got an inheritance coming, a lot of people have bills and they need to pay credit cards and medical expenses and things like that. And the longer you wait, the more it's going to cost you. And so you really want to get your inheritance as quick as possible to take care of those things. But the trustee has to be very careful and not distribute things too early before they know what the whole picture looks like. It can take time for creditors to come out of the woodworks. And if a trustee distributes, 50, 60, 70% of the assets right off the bat. And all of a sudden, you got a creditor come in that claims that the estate owes more than 50% of the value. Now, what is the trustee supposed to do? They're going to have to figure out how to pay that bill with the money that's left in the estate and try to claw it back from the beneficiaries who have probably already paid that money to other financial institutions. So
Yep.
it's really important that I know people want to get the money as soon as possible, but it's really important to be patient with your trustee.
Yeah. And who are creditors? I mean, you're talking about obviously individuals or something, but banks and credit card companies, like who
Yeah,
would be a creditor?
yeah, all of the above. It's anybody that the person that died owed money to. So it could be credit companies, it could be mortgages, it could be loans, like personal loans. If they have a business, any accounts payable, things along those lines.
What about medical? What about medical debt?
Yeah, absolutely. Medical bills. Yeah, if somebody was really sick, had cancer or something like that when they were dying, those medical bills can really add up, and those have to be dealt with. You don't necessarily, as a trustee, you don't necessarily need to just pay those either. There may be ways to reduce the amount that's owed or not pay some of the bills at all. But that's something that needs to be calculated by somebody who knows the laws, the creditor laws.
Interesting. On the what if someone is not married, Phil, and the kids are adults, not married, the person dies, and they have like medical debt. Like, who's responsible for that?
Yeah, that's a good question. So whenever somebody dies, the beneficiaries, other than a spouse, the beneficiaries are not personally liable for any debts of the estate. So
Okay,
let's say the estate had $1 million and it had $1.5 million in debt. The beneficiaries don't have to come up with that extra $500,000 to pay the creditors. It's just that million that goes to the creditors, and then the beneficiaries get nothing. So they're not personally liable.
got
Uh,
it. Okay, and you can
and
set up some
so that's
asset
another reason
protection.
it's important to know how much is owed and how much is there before any money gets distributed.
Interesting. And but you can also set up some
Oh,
asset protection planning, right?
absolutely. And sorry, I wanted to add one more point. If the trustee does distribute to the beneficiaries, then the beneficiaries could become personally responsible for the additional debt above what they received. So you don't want to take money if it's going to cause you to owe more than you're inheriting.
Interesting. Oh, because the creditors can go after the beneficiaries.
Yeah, directly.
Okay. All right. Um, well, let's say you're transferring everything to your kids as an asset protection trust that's set
Hmm.
up before you pass away. That's going to guard it, correct?
That's going to what?
Guard it, protect it from creditors?
Not necessarily. It depends on if the estate is insolvent, then it wouldn't. But if the estate is solvent, it has more money than owed to creditors. Then yes, the money that goes in that trust would be protected for the beneficiaries.
So let's say you pass away. The last question on this got me curious because this came up with our firm. You pass away, but you have your assets already have been distributed into an asset protection trust for the
Gotcha.
benefit of your
Gotcha. Sorry, I
kids.
misread you there.
Yeah. Are you good with that scenario?
Depends. So when you set up an asset protection trust, one of the requirements is that it cannot be a fraudulent transfer or avoidable conveyance. And so when that transfer is done, as long as it doesn't violate that rule, then yes, that money is gone. And if you were to die owing a lot of money to creditors, they can't come after what's in those asset protection trusts.
Got it. Okay. Okay. Awesome. Addressing a few questions here. What are the costs of trust administration? Is it flat fee per hour? How do you work that, Phil?
It all depends. We try to do everything flat fee to make sure that we're completely transparent on costs. And most of our trust admins we do, but you get some that are just so difficult to predict what's going to happen that we do hourly. Situations where there's a lot of beneficiaries. We've had cases where there's 40 or 50 beneficiaries, and it's just you never know how when one of those beneficiaries is going to go rogue and start causing problems. And so in that
Yeah.
situation, you really need to do it hourly and take it step by step. Another one is where it's really difficult to determine what the assets are, who manages the assets. We recently had one where the client had a couple of businesses set up, but the businesses hadn't been administered properly since 2017. And it was it was almost impossible to determine who actually had control of those businesses. And
Yeah.
so we needed to go to the court to get the court to intervene and appoint somebody to be in charge of those businesses. In that case, it's just too hard to do hourly. We've got to, I mean, sorry, to do flat fee. We've got to do hourly.
Right, right, right. Yeah. And it's for us, I know the way our firm works, open door policy on fees, there's,
Absolutely.
yeah, I mean, we know everyone's got a budget, and so we get it, and it's just everything's on the table. Someone's saying they have two different inheritances, one in New Mexico and one in California. What does that get into?
Yeah. So each inheritance would be governed by the law of that state. You have for death taxes, you have the federal estate tax, and that is 40% on any amount over 15 million right now, but that changes every time we get a new government.
Yeah.
Um, for the state of California, there is no state death tax, and also for New Mexico, there is not a state death tax as well. But fiduciary duties might be different in each state. They're probably going to be very close, but there may
Yeah.
be some small nuances that are different in each one.
Okay.
Um, and then the probate, if there was no trust in place, the probate would have some slight nuances as well.
Okay. And what about someone's asking, how do you monitor a trustee, or can
Good
you
question.
monitor?
Yeah, that's a good question. So trustees have a lot of power. The key term in the word trustee is trust. The person that set up the trust originally has to have a lot of trust in that trustee because they have a lot of discretion. Again, there's times where the trustee needs to communicate and times where they have discretion to communicate. And so, based off of the communication, you're going to be your best way to monitor them. If you think that you're not getting enough communication, then you can request more communication, and then try that way. But the trustee may or may not have a duty to respond to your request. The first thing that governs that is the trust itself. The trust is going to say what situations the trustee has to communicate. If the trust is silent, then the state law steps in and fills in the blanks.
Okay. Okay. Yeah, because someone's asking about a breach of fiduciary duties, which gets into what? Trust litigation, right?
Absolutely. Yeah. Unfortunately, we see it all the time. And I got to tell you, most of the time we see it, it's not a breach of fiduciary duty. It's just the beneficiary being impatient or not understanding the process. Most of the
Yeah.
time, the trustee is doing their job. I mean, just like everything, there's bad attorneys out there, there's bad cops out there, there's bad trustees out there.
Yeah.
Just not every one of them is bad, and very small percentage are.
Yep. Yep. Well, Dean's asking, our parents' trust was established in California. One trustee borrowed heavily from the trust and cannot repay. Does this end up as a civil case, criminal case? What happens?
Yeah, so 99.9% of situations like that where the trustee is doing something wrong is a civil case, and it would be trust litigation. Again, every once in a while, there is something that's done that is so heinous that it rises to criminal proceedings. But most of the time, and the beneficiary can't institute criminal proceedings. That's something that the DA would have to do. The beneficiary could file a civil suit, though.
Okay. Okay. Uh, what about special needs trust? I know a little bit off, on a sideline here, but someone's asking about special needs trust.
Yeah, I mean, it's kind of off topic, but
Right.
briefly,
Yeah.
we
Yeah.
do special needs trusts. The whole point of a special needs trust is to allow somebody that is getting government supplemental income or somebody that cannot manage their own money. It gives them the ability to inherit money and not disqualify them from the benefits and not waste the money that's inherited. And the brief rundown of how it works is somebody sets up the trust for that beneficiary. They then give the money to the trustee to hold for the beneficiary, and the trustee has complete control, but the trustee has to use it for the beneficiary, and that's how it protects them.
Okay. Someone's asking, what if accounting was never provided?
Good question. That's back to what the trust says. Most trusts say that there's an annual accounting requirement, but there's no need for that. The trust could literally say there is no need for the trustee to provide any accounting to the beneficiary. So you really need to look at the language of the trust to see what it says.
Okay. My spouse and I have a trust since 2015, but I notice it needs to be updated. Does your company work with clients to update the trust? We reside in Northern Cal and not wish to go to SoCal, able to work remote. I know the answer, but you go ahead, Phil.
Yeah, absolutely. That's a great question. So we would be happy to review any of your estate plans for free. We do not charge for that service. Again, we help everybody all over the country, so there's no need to come to our office. I am actually probably closer to you than our office is. I'm actually in Northern Nevada. So we help people everywhere. There's ever since COVID, remote working has become really easy. And so we have tons of clients that we never see, they never step foot in our office. So
Yeah.
absolutely we'd be happy to help you with that.
Yeah, and shout out to Northern California. I'm in Marin County, just over San Francisco. So we're neighbors.
Yep.
Okay, let me keep going here. These are great questions. Love it. What happens if there are two trusts with conflicting trustees and beneficiaries?
So when you have two trusts, let me back up. So to make a trust work, you have to fund the trust. And funding the trust means transferring the assets into the trust. And if the assets aren't transferred into the trust, then the trust doesn't control those assets. So if there's two trusts, if trust A says one thing and trust B says something different, trust A only governs the assets in trust A, trust B only governs the assets in trust B, and therefore there's really no conflict on it.
Okay. Okay. And I just put up the link again in the chat. So if you go to chat, you'll see a tiny URL link. If you click on that, fill that out, it'll take you a second, name, contact information. That will get you booked for a complimentary call with Phil. It can be a Zoom video or a phone call, but that's the link there. I just put it in there. Okay. So,
You want me
uh,
to hit the rest of these bullet points pretty
yeah,
quick?
yeah, go, boom, hit them.
Yeah. So, not getting a data death valuation, one of the benefits to, well, I'm not going to say benefits, but one of the things good that comes out of a family member or friend or whoever dying is that their assets get a step up in basis, meaning all the capital gains tax that would have been owed get erased. And so let's say you inherit real estate from your parents, and at the time they bought it, it was worth 100,000. At the time of their death, it was worth 1 million. If your parents had sold that the day before they died, they might owe 900,000 worth of capital gains taxes, the difference between 100,000 and 1 million. But the basis gets stepped up to 1 million at their death, meaning that if you were to sell the property later, say for 1.5 million, you would pay tax on that difference between 1 million and 1.5 million, so 500,000 rather than from 100,000 to 1.5 million. And
Okay.
so it's really important to make sure all those assets get a data death valuation so that when you do sell those assets that you can report properly what the initial basis was.
Okay. And Phil, just a quick point on that. We've got a question. If someone dies, does the automatic Social Security monthly payments and other annuity payments stop immediately? How can you continue payments of bills during the period of internment and trust administration?
Yeah, so that is supposed to stop immediately. Several years ago, they made a requirement that the morgue report that to the government to let them know that, stop making those payments. Technically, whoever's in charge of the estate has the responsibility to notify them. So if you're the trustee of the trust, that's the responsibility you have. If you get named inside of a probate, that's a responsibility you have as well. And the payment should stop. If you're continuing to get payments after someone has died, obviously, if it's a check for the time that they were alive that got distributed afterward, that's fine. But if it's for time accrued after they died, that money is owed back to the government. And so you need to make sure that you keep that separate and figure out how to get that back. Um, and how do you pay? If there's money in the estate and you can access that money, then you pay that way. If there's no, well, let's take both scenarios. If there's money there but you can't access it, if you're the trustee, then all you need is a death certificate, you need a certificate of trust, and you need a taxpayer ID number, and you can go to the bank or wherever to access that money. If there is no trust and you got to go through a probate, then you got to wait 3 to 4 months to get appointed by the court to do that. If there is no money, you always have the option to use your own money and get paid back from the estate, but you're under no obligation to do that.
Okay. Someone's asking here, as trustee, I found all my time and work for the, I found out that all my time and work for the trust have ability to be reimbursed, but never submitted an invoice, any invoice. Can I invoice my time and money spent on the trust work? What is the usual fee for reimbursement in California?
I think we need to talk about that more individually because it
Okay,
just depends on what the trust says.
okay.
Um,
So you'd have to
there's
look at the
no
trust and,
typical,
yeah,
there's no typical fee. It's entirely up to the person that created the trust as to what they want that to be, and when and how long it's been since the trust administration's been done or started as to when you can request the money. One thing to keep in mind though is when you are getting paid as a trustee, that's considered income, and you have to pay taxes on that.
okay, okay. All right. You want to keep hitting those, Phil?
Yeah, so back to the data death valuation. So the first thing is the step up. You want to make sure you have the valuation for the step up purpose. But the other one is if you do live in a state that has an inheritance tax, or if you're close to or near the federal exemption of 15 million, you want to make sure that you get a really accurate valuation so that you know how much tax you need to pay, or maybe you don't need to pay tax at all. Um, Mishandling real estate, it happens all the time. The biggest thing that I see is property tax. Different states have different property tax rules. California has a somewhat unique system. There's a couple other states that have similar, but California has a system where somebody could have a property worth $5 million, and they're paying property taxes if the property was worth $100,000. And when somebody dies, that can change. And you can go from paying a couple $1,000s in property tax a year to $100,000 in property tax a year in that scenario. And if it's not addressed properly, then the family is going to have a rude awakening. And the assessors are so backed up, it takes almost a year to get that assessment. So you may not even know that it went from 2,000 to 100,000 for a year. And now all of a
Oh,
sudden, if you distributed the assets too early, how are you going to pay that bill? Um,
yeah.
so that's one of the issues with mishandling real estate. Another one is, dealing with tenants. We see a lot of times one child lived with parents and doesn't want the house to be sold, doesn't want to move out, but really couldn't sustain the house on their own. And so you can't just force your sibling out of the house or have the police come and get them out or throw their stuff out or any of that. You got to go through a court process to make sure that's done properly. And so we see that happen a lot as well.
Yeah, I get
And
all
that
the
can
time.
lead to criminal charges, assaults and trespassing and things like that. So, even if you have a key to mom and dad's house and your sibling lives there, that's their house. You can't just walk in anytime you want. That's criminal trespassing,
Okay, okay. All right.
even if you're the trustee.
Yep, yep. Expenses, did we cover expenses?
Yeah, I mean, forgetting about expenses, I don't really see forgetting too much. It's more of not doing your due diligence to discover what all the expenses are.
Okay. All right.
Ignoring required legal notices, absolutely. That's one of the things. There are some requirements of things that need to be sent out, and if you don't do that, you could be in breach of your fiduciary duty.
Okay.
Filing required tax returns, again, just because somebody dies doesn't mean the taxes go away. Their personal income tax returns need to be paid. There may need to be a trust tax return done, a 1041 instead of a 1040. You may have some capital gains tax returns to do. In California, when you sell real estate, you got to fill out a 593 right off the bat. There's a bunch of different tax notices and returns that need to be done. So it's really important that you understand all that.
Okay. And yes, I'm just saying we will be emailing, look for your email, a replay of this as a follow-up. So if somebody asks that, we will get that out.
Yeah,
Uh,
and obtaining the data death valuation, there's a couple different ways. The best ways to do it is for business, get something called a valuation. And that's where a professional that's licensed to give a value to a business comes in, looks at all the numbers and metrics and how the business runs and everything, and they come up with what they believe is a fair value. And they have different methods of calculating that. And but the point there is that they are licensed to do it, and if they come up with the value and you report that to, say, the IRS is going to trust it because they're a trusted person. With real estate and things like that, you can get an appraisal done. Again, somebody that's licensed to do that. With stocks and commodities, you get basically an average value of the date of death. And as long as you use all of the methods, you have no problems. Some people want to use comps or, 3 times EBITDA or something like that to determine a value. And if that were to be challenged by the IRS, now it's up to you to prove how you came up with that number and why it's correct versus hiring an expert to do it. And then they're the ones that are on the hook.
Got it. Okay. All right. All right. A simple slide here. Trust does not avoid probate. What's going on with this?
Um, yeah, so I think I want to back up one step, and a will
Okay.
does not avoid probate no matter what. So just because you have a will doesn't mean you avoid probate. You have to have a trust to avoid probate. But I mentioned this once before, to have a trust avoid probate, the assets have to be in the trust. And there's proper ways to title each asset in the trust. Real estate, you have to file a deed with the county recorder. Financial accounts, you have to go change the title and the beneficiary on the accounts. Retirement accounts, you have to change the beneficiary. If you don't do that, then those assets that are not titled in the trust will still have to go through probate, even though you have a trust.
Okay. Okay. All right. All right. So we got this one covered, probate, Phil?
Absolutely.
Okay. All right. Poor outdated trust break families. We see this all the time. I think one of the recent stats I saw, Phil, was 65%, 70% of Americans don't have a trust in place at all. And then of the ones that do, much of that is outdated or was poorly written. What is your comment about this and what you see with families?
Yeah, we see it all the time. I think we spend more time fixing poor and outdated trusts than we do creating new ones, by far.
Yeah.
Um, Outdated trusts cause a lot of issues. Excuse me. Unfortunately, our country has become so polarized um, between Republicans and Democrats that every time one party shifts control to the other, our laws completely change. And those laws affect your trust and how taxes may be paid when you die. And so every time we have some kind of election where the power shifts at all, you need to have your trust reviewed. Um, if you have a trust that's 30 years old and you've had births in the family or you've had deaths in the family or somebody you've named has died or maybe you don't even talk to somebody you named, that creates a huge issue as well. You need to have the trust reviewed and edited whenever those occurrences happen. Divorces are probably the number one. You have a trust between a married couple, and while they're going through the divorce process, they're named on all each other's documents.
Yeah.
We've seen the case where husband and wife are getting divorced. Husband ends up on life support, and guess who gets to make the call? It's the wife that he's divorcing from as to whether or not to pull the plug. That's awful. You never want
Yeah.
that to happen.
Yeah.
Um,
Yeah. Yeah. The divorce thing is a huge one because there's so much divorce now. And the calls that come in or you're handling those as you're talking about is people don't redo their planning. And then there's a lot of gray divorce where people are bringing assets into a new marriage. They're bringing, there's step kids involved. And that's where it just gets like sideways.
yeah. And then breaking families up, siblings may not have been on the best of terms before parents died, but at least they were on decent terms and talking terms. But now, if one sibling thinks that they were entitled to something that the other sibling doesn't or wasn't written in the trust, now they start suing each other, and all of a sudden you have siblings that have one wasted all the parents' money on lawsuits, but two will probably never talk to each other again. Those parents are turning in their graves knowing that their death caused their kids to hate each other that much.
Yeah. Yeah. It is horrible.
And just having a properly written trust can avoid that. You need to have everything clear in the trust to make sure that nobody has any expectations that aren't written down.
Yep. Yep. Nope. We see it. All right. Any specifics with business owners and rental property owners?
Yeah, I mean, I briefly touched on this earlier. Business owners, it's terrible if you do not have a plan in place for your business if you were to die unexpectedly. Your business literally could come to a grinding halt if you don't have a plan in place. And sometimes it's not just having a trust. If you have partners in your business, you
Yep.
need to have some kind of succession plan to
Right.
determine what happens with the partners. If say Paul and I are partners, and I were to die, Paul, because, and let's say I do have a trust in place, it says my interest in the business goes to my spouse. Well, Paul now becomes a partner with my wife, and my wife doesn't know anything about our business. And Paul doesn't want to be a partner with my wife. He doesn't want her to have an input because she doesn't know what she's talking about. And so you really need to have a succession plan in place and make sure that the family of the deceased gets compensated equitably with money, but that the control can still remain in the partner or remaining partner's interest.
Yep.
And so there's a lot of things that go into that. How do you buy out that partner that did pass away? If the business is, struggling to make it buy, you need to have a buy-sell agreement with some kind of funding and life insurance in place. A lot of different things for business owners.
Yeah, we do a lot of that planning. I know you do a lot of that planning too for business
Absolutely.
owners is yeah, they go hand in glove, this trust planning and the business planning.
Yeah. Real estate, I did touch on this earlier. You could end up in foreclosure or have property tax consequences if you have to go through probate and nobody's paying the mortgage.
Right. Right. Yeah. And Phil, what about owning real estate, rental income properties, and just real quick, does this apply in your living trust versus the LLC? I mean, as I often hear you talk about LLC help, can help with smoother planning. Is that
Absolutely. Yeah, no, an LLC is definitely one good way to plan. But again, you have to keep in mind, do you have partners in that LLC? A lot of
right?
states
Right.
don't give protection to a single member LLC. So we set up a lot of multi-member LLCs, and that's something that you need to consider upon your death. What's going to happen to that membership interest? Um,
Yep.
but yeah, an LLC is definitely a good way. If a property is in an LLC, and the LLC is properly accounted for, then it wouldn't have to go through probate. But again, you've got to have the proper planning in place ahead of time.
Yeah, and it's interesting as you're talking about the businesses, we've have a lot of, very successful Amazon sellers as clients, and a lot of them are just young, they're not married. I mean, they're in their 20s, 30s, and they're making a lot of money.
Mm-hmm.
Amazon resellers, they have no idea that they need any planning. And if something happens to them, they got nobody. They're not married, they got no kids, they're young, and they have a very, very successful Amazon business. It just wreaks havoc if the planning isn't done properly for solopreneurs like that.
Yeah.
Yeah. All right. Let me blaze through here. Um, we touched on this a little bit, but what's the personal liability of a trustee? I mean, a lot of times I think trustees, people don't really put a lot of thought into picking their trustee. Well, they just, do this person, and then the trustee has no idea what they're getting into. What do you see there?
Yeah, I mean, I talked about some of the duties of the trustees earlier, and again, you could be civilly sued or criminally punished for doing things wrong. And most people that get named as trustee don't understand what it means to be trustee. Most people creating a trust and naming someone as trustee don't understand the huge
No.
responsibility that they're putting on that person. And a lot of the times we recommend, hey, this is a bigger enough estate. There's enough complication. There's enough beneficiaries. There's enough fighting. You should probably consider hiring a professional trustee, whether it's a bank or somebody, a small little shop that's all that they do. You can put somebody in charge that knows what they're doing and isn't going to have any issues. But for some families, it's not a big enough estate, or it may be easy upon death, and so they just name family members as trustee. And in
Yeah.
that situation, that trustee's got a lot of weight put on their shoulders. And at any time, that trustee could just say, you know what, screw this, I don't want to deal with this anymore. This is a lot of responsibility, and they could resign. So it's really important that you have backup trustees, and at some point in time, maybe have the final backup trustee be a professional who is not going to resign.
Yeah, and Phil, I've heard you talk about before is you may have two people involved in your trust. Like for
Oh
instance, the
yeah,
people you put in charge of taking care of your kids, God forbid something happens, you have minor kids, might not be the best person to handle your financial affairs.
absolutely. Yeah, you can split the trustee duties. You can name different trustees for different things. You could have an administration trustee and an investment trustee. You could have a distribution trustee separate. You can name all different kinds, um, and that's good. You can separate the responsibility and let the people who are good at what they do what they do. But what you almost never want to do is give two people the same hat and have two administrative trustees, because that creates fighting, and that is one of the most common ways to start litigation in a trust.
Well, so Dean's asking, can a family trustee be fired?
Fired depends. Usually most trusts have safeguards in place saying that if they breach a fiduciary duty, and a lot of trusts will outline what those duties are, but if not, then it goes back to the state probate code or the state business and professions code as well. And if they breach one of those duties, then the beneficiary could petition the court to remove the trustee. Again, it's litigation. It's not cheap. You're going to spend $10,000 to $20,000 to do that, and probably take 6 months to a year to get that accomplished.
Yeah.
In some of the more well-written trusts, you may have somebody in there called a trust protector, and that trust protector may have the ability to remove a trustee as well. So again, it just depends on each individual trust and what they say.
Okay. For properties in an LLC, would they have to get retitled in name of trust, or can transfer membership interest only?
Yeah, so you can do it two ways. You can do an assignment of the LLC membership interest to the trust, or you can make sure that the LLC itself, the members are the trustees of the trust. And so that would usually be on the internal operating agreement and exhibits. And in some states, you may have to file that with the state as well.
Okay, I'm just putting this in again because someone's asking for it. All right, there's the link. I just put it again in case you haven't seen it. Somebody wanted that in the chat. Look in the chat. Okay, so this last slide here, Phil, and we'll maybe take a few more questions after this. But what to do right after death?
We get phone calls like from clients that have been clients for a long time, usually upon the death of a first spouse, and the surviving spouse calls us literally within hours of the person dying, saying, "Oh
Yeah.
my goodness, my husband died. What do I do?" And we tell them, "Go grieve and deal with family and take your funeral and things like that. Don't worry about the legal aspects. Give it a month or so and then call us back.
Okay.
At a minimum, wait till you have death certificates because you can't do anything until then anyhow."
Oh, okay.
But other than that, like I said, there's deadlines. So, you don't want to go too far past a month, um, because you got to start meeting some of those deadlines. But definitely the first thing you should do is, after you've dealt with the grieving process and family and everything, is look at the documents, see what they have in place. Do they have trusts? Are the assets titled in the trust or transferred to the trust properly? Are there any bills that need to be paid right away? Monthly credit card or mortgage payments or health. Well, it's not health insurance anymore, unless it was the primary person who had the health insurance for the whole family. Yeah, you need to make sure that you as a surviving spouse and your kids still have insurance as well. So things like that are what need to happen right after death.
Okay. And Bridget, yes, we are getting a copy of the recording out. So just look for your email or give us maybe 24 hours. We're just gonna do a little editing to get it out to you, but look for your email. We'll get the replay out. And Phil, I had a question just on the do after death when we're doing a trust for somebody, are we giving them a copy, is a digital and physical copy of the trust? Do they get that?
Good question. Yeah. So we will do a physical hard copy that's got the notaries and signatures and everything, and we will give that to you. We will just keep a digital copy only. We will also give you a digital copy as well. Again, one of the benefits of having a trust and an estate plan is that it's all private, confidential information. So you have no obligation to share that information with anybody. However, if you've named somebody as an agent, trustee, executor of your trust or will, then it would be really helpful for them to have those documents in case something happened to you unexpectedly. So it's something you may want to consider sharing with them. And obviously, the easiest way to do that is digitally.
Awesome, love it. And then I want to say as we get to the ceiling here, I want to say thanks everybody for being here. We're hitting the wall here. Phil, awesome stuff. And again, I want to encourage everybody, get with Phil. It's not going to cost you anything, or if you need an update, review of what you currently have, or you don't have anything in place, get acquainted with Phil. Phil's the one that actually does the work. If you have something that needs to be done. Phil, incredible. Love it. Thank you.
Yeah, thanks everybody for coming, and hopefully everyone's staying dry and warm out there.
Yeah, you got, yeah, that's great. That's great. All right. We'll see everybody next time. Thanks.